Hello, can you hear me now?
Yes, my lord.
Yeah. Can you call the first case for judgment? Call the first case for judgment. Can you call the first case for judgment? Can you hear me, please?
My lord, we can hear you. My lord, we can hear you.
Oh, okay, thank you. Yes, the registrar should call the first case for judgment.
Hello. Mike, much it.
Can you call the first case for judgment, please?
Yes, my lord. Resume today.
Go ahead.
Yes, my lord. Resume today, Friday, 29th April 2022. Before His Lordship, Honorable Justice P.I. Harman. Suit number 9/PX/142, 2018. Between Mr. Harrison Sunday and Sidri Mobile Units Nigeria Limited.
Yes, is the claimant, the parties are there, huh?
My lord, respectfully, sir.
Yes.
O.A. Owolabi, I humbly announce appearance for the defendants. With me is my learned
O.A. Owolabi.
O.A. Owolabi, my lord. With
yes.
N.A. Epo, my lord. N.A. Epo.
N.A.
Yes, my lord. Epo is spelled E-K-P-O-H, my lord. Our appearance is for the defendants, sir.
Is the claimant's counsel around? Any appearance for the claimant?
Yes, my lord.
Okay.
Hello?
Can I take your? Yes, go ahead.
Hello?
Yes, who is appearing for the claimant?
My lord, sorry, I represent my boss, Barrister Confidence on yes, he is A, so I'm his secretary. That will stand for him.
Sorry, I can't get you. Who is the counsel for the claimant, please?
My lord, the counsel for the claimant is Barrister Confidence on yes. So I'm his secretary. My name is Wisdom Tochukwu.
You can't announce for counsel, secretary of the chamber. I'm taking representation of counsel, please. You cannot announce for. You can only monitor the judgment, please.
Okay, sir. That's my lord.
Yes, this is the court's judgment. This suit was commenced by way of complaint and statement of facts on the 6th of December 2018 by the claimant against the defendant, where he claims as follows. 1, and order that the termination of the claimant's employment with the defendant without any notice or salaries in lieu is wrongful. 2, an order that the claimant is entitled to group life policy and group personal accident insurance scheme from the defendant. C, an order that the claimant sustained serious crush injury on his right leg on the 4th day of January 2013 while on duty at the defendant's West Solari Street at Zaba Zaba 3, Ajib location in Port Harcourt, River State. D, an order that the defendant shall pay to the claimant the sum of 5 million naira, being the out-of-pocket expenditure incurred during the period of his abandonment, medical bills, and tradomedical expenses and drugs and treatments at the chemist. E, an order for the sum of 20 million naira, representing general damages against the defendant for the consequential abandonment of the claimant at the clinic while suffering neglect and psychological and physical trauma which the claimant was subjected to. And F, an order for the payment of the claimant's monthly salary, A, basic salary, 134,300 naira. B, transport allowance, 35,000 naira. C, housing allowance, 100,000 naira. D, utility allowance, 15,000 naira. E, child education allowance, 24,000 naira. Total, 308,300 naira. For the period between July 2013 until judgment is delivered by this honorable court, and an interest rate of 30% of the general sum. And G, an order that the defendant shall pay the sum of 616,600 naira only, representing the claimant's 2-month salary in lieu of the termination of his employment at the determination of this case. The defendant's statement of defense, list of witnesses, witness statement on oath, list of documents and front-loaded documents were filed on the 13th of September 2019, but deemed by the court as properly filed and served on the 16th of December 2019. The claimant filed a reply to the statement of defense together with further witness statement on oath on the 19th of November 2020, but deemed as properly filed and served on the 24th of November 2020. With the leave of court, the defendant filed a substituted witness statement on oath on the 22nd day of March 2021. Trial in this suit started on the 24th of November 2022, when the claimant opened his case by testifying for himself as CW. The witness who affirmed to speak the truth and spoke in English language identified and adopted his deposition that was filed on the 6th of December 2018, and the further deposition that was filed on the 19th of November 2020. The following documents were then tendered through the claimant and admitted by the court. 1, offer of fixed term contract of service dated 9th of October 2012, Exhibit CW1A. 2, work fitness certificate dated 27th of March 2013, Exhibit CW1B. 3, claimant's letter dated 21st of January 2013, Exhibit CW1C. 4, DHL proof of delivery dated 29th of October 2018, Exhibit CW1D. 5, DHL way bill dated 23rd of August 2018, Exhibit CW1E. 6, solicitor's letter of CEO Onyeso and Associates dated 16th of August 2018, Exhibit CW1F. 7, solicitor's letter of Charlene Attorneys dated 7th of March 2016, Exhibit CW1G. 8, solicitor's letter of LCO Mehiale and Company dated 30th January 2013, Exhibit CW1H. And 9, Avon Specialist Hospital Limited Medical Report dated 24th of July 2017, Exhibit CW1J. 10, email written by one Yomi to the claimant is Exhibit CW1K. The witness CW was cross-examined by the defendant's counsel and discharged without any re-examination. The claimant then closed his case on the 3rd of February 2021. The defendant opens his defense on the 14th of July 2021 by calling his sole witness, Titilola Olusekun, the real controller of the defendant, who testified as DW. The witness who affirmed to speak the truth and spoke in English language identified and adopted her deposition that was made on the 22nd of March 2021 before tendering the following documents which were admitted by the court. 1, offer of fixed term contract of service dated 9th of October 2012, Exhibit DW1. 2, solicitor's letter of LCO Mehiale and Company dated 30th January 2013, Exhibit DW2. 3, defendant's letter to LCO Mehiale and Company dated 19th of February 2013, Exhibit DW3. 4, Nigeria Social Insurance Trust Fund letter dated 24th of February 2014, Exhibit DW4. 5, solicitor's letter of challenge attorneys dated 7th of March 2016, Exhibit DW5. 6, solicitor's letter of challenge attorneys dated 6th of April 2016, Exhibit DW6. 7, Nigeria National Petroleum Corporation, National Petroleum Investment Management Services, letter dated 11th of January 2018, Exhibit DW7. 8, email from Olajumoke Adeyemo, dated 20th February 2018, Exhibit DW8. 9, defendant's letter to NNPC NAPIMS, dated 8th of March 2018, Exhibit DW9. 10, defendant's letter to the Nigeria Social Insurance Trust Fund, dated 9th of March 2018, Exhibit DW10. 11, Nigeria Social Insurance Trust Fund, letter dated 26th of March 2018, Exhibit DW11. 12, defendant's letter to the Group General Manager NNPC NAPIMS, dated 5th of April 2018, Exhibit DW12. 13, solicitor's letter of CU Onyeso and Associates, dated 23rd of August 2018, Exhibit DW13. And 14, Nigeria Social Insurance Trust Fund, letter dated 23rd of July 2013, Exhibit DW14. The witness was cross-examined by the counsel to the claimant and discharged without any re-examination. The defendant closed his case on the 14th of October 2021. With the close of evidence, parties were directed to file their final written addresses, beginning with the defendant. While the defendant's final written address was filed on the 15th of November 2021, that of the claimant was filed on the 2nd of December 2021. The defendant filed a reply on points of law on the 28th of January 2022, which was deemed as properly filed and served on the 2nd day of February 2022. These processes were adopted by counsel on the 2nd day of February 2022, with A.O. Imagozege appearing for the claimant, while N.A. Ekomisis held a brief of A.O. Owolabi for the defendant. Now the case of the claimant. The claimant, who was employed by the defendant as a roustabout void fixed term contract of service dated 9th of October 2012, sustained industrial accident to his right foot at about 11:30 p.m. on the 4th of January 2013 at the defendant's West Polaris rig at Zabazaba 3 Ajib location, Port Harcourt. The claimant was quickly rushed to the International SOS Medical Center at SMI Clinic Limited, Inter Camp, Port Harcourt, and hospitalized for about 7 months. That while in the hospital on sick bed, he wrote to the defendant's country manager, Mr. Moses Akenua, who called the claimant on phone and acknowledged the letter, but advised the claimant to engage the services of a lawyer to write to the defendant. According to the claimant, while the treatment was still ongoing, the defendant called for his discharge from the clinic, contrary to the medical advice and opinions of the medical doctors, and further treatments were accordingly stopped by the hospital. That he was sent out of the clinic amidst the excruciating pains and left to his fate towards the end of July 2013. That despite a series of letters written by his solicitors to the defendant did not respond to the letters. That from when he was abandoned by the defendant, he has been living on the charitable support of some family members, friends, and well-wishers, and has spent the sum of 680,000 naira with a balance bill of 220,000 naira at Avon Specialist Hospital Limited, where he was hospitalized between 13th of June 2017 to 24th of July 2017. That since his family has suffered untold hardship and deprivation as a result of his inability to gain employment in other companies due to his condition, the court should grant his claims in this suit. Now, the defendant's case. The defendant aversed that as an affiliate of offshore drilling contractor, it employed the claimant to work on one of its rigs, known as West Polaris, as a rostabout for a fixed term of 3 months, by contract letter dated 9th of October 2012, that the contract was to commence on the 1st of November 2012 and to terminate on the 31st of January 2013. That while it is correct that the claimant sustained injury to his right foot while working on the West Polaris, the defendant, through its management and employees, rushed the claimant to the International SOS Medical Center at SMI Clinic Limited, Intel Camp, Port Harcourt, where he received medical attention and treatment. That the defendant bore the cost of the medical care until the claimant was discharged from the hospital. According to the defendant, it neither abandoned the claimant in the hospital nor compelled or forced the hospital to discharge the claimant as alleged by him. That since from the terms of the contract of employment, the claimant was entitled to coverage under the Employee Compensation Act in the event of any industrial injury in the course of discharging his lawful duties, the claimant and other employees of the defendant were placed under the insurance cover of the Nigeria Social Insurance Trust Fund, NSITF. The defendant further advised that while the claimant was still on admission at the hospital, the contract of employment ended by a fraction of time, that based on the notification to NSITF of the industrial injury sustained by the claimant and the request for compensation for the claimant, NSITF requested for the documents required to process the application for compensation, which was communicated to the claimant, including the necessary forms for him to fill, but the claimant refused to fill the forms. That despite reminder to the claimant, he still could not fill the forms correctly and failed to attach the required documents to NSITF. It was further averred that rather than filling the forms appropriately and submitting the necessary form to enable NSITF process his compensation, the claimant engaged the services of a lawyer who wrote a letter of demand to the defendant. And the claimant also wrote series of petitions against the defendant to the Nigerian National Petroleum Corporation, NNPC, through the National Petroleum Investment Management Services, NAPIS, that the defendant procured another form from NSITF and sent to the claimant to fill and return along with the necessary documents on or before the 23rd day of February 2018, because the application could no longer be entertained by NSITF, but the claimant only returned the forms to the defendant after the expiration of the stated deadline of 23rd of February 2018, and when the forms were submitted to NSITF via letter dated 9th of March 2018, NSITF responded via letter dated 26th of March 2018 that the claimant's claims had become statute barred by virtue of the Employee Compensation Act 2010. According to the defendant, the instant action is an abuse of court process, frivolous and vexatious, and should be dismissed with substantial cost against the claimant. Now, defendant's submissions. The learned counsel to the defendant identified the following two issues for determination in this suit, to wit, A, whether the defendant actually terminated the employment of the claimant, and B, whether the defendant is obliged to pay the claimant any of the monetary reliefs couched as reliefs D, E, F, and G on the complaint and statement of facts. With respect to issue 1, it is submitted that the claimant's pleadings are inelegantly drafted and a bit confusing because relief A should have been for a declaration and not an order, that an order by its nature has a compelling effect and usually directs a party to a suit to mandatorily carry out or refrain from doing a certain act. Reference was made to the definition of order in the 10th edition of the Black's Law Dictionary at page 1270. Learned counsel drew the attention of the court to paragraph 1 of the contract of employment, that is Exhibit CW1A, and submitted that the contract was determined by a fruition of time and not by termination, because it was for a term of 3 months certain, commencing on the 1st of November 2012 and terminating on the 31st of January 2013. The parties are bound by the terms of the contract they entered into. That from the solicitor's letter of LCO Imehiele and Co., which is Exhibit CW1H, the claimant was aware that the contract had expired, hence their request for an extension of the contract by 1 year in view of the injury sustained by the claimant on the 4th of January 2013. The court was urged to refuse the claimant's relief number A on the complaint. With respect to issue 2, it was posited that from the facts and the evidence on record, the defendant is not obliged to pay the claimant any of the sums claimed as reliefs D, E, and F, because any compensation due to the claimant will only be derived under the provision of the Employee Compensation Act. On relief D, it was argued that apart from the fact that no evidence was adduced by the claimant to substantiate this claim, his evidence in chief clearly confirms that this assertion is false and self-serving, referring to paragraph 6 of the claimant's witness statement on oath filed on the 6th of December 2018, that the claimant's contention that the defendant abandoned him after the accident and didn't provide adequate medical care is untenable, as he clearly admitted that he was treated for a period close to 7 months at International SOS Medical Center in Port Harcourt. That in another breath, the claimant stated during his cross-examination that the defendant stopped SOS Medical Center from providing him with any further medical care a day after he had the accident. According to learned counsel, there is inconsistency in his evidence at paragraph 6 of his deposition, where he admitted being treated for 7 months, and the evidence elicited during his cross-examination, where he claimed being abandoned a day after the accident. The court was urged to treat the claimant as an unreliable witness, discredit him, and not to attach any weight to his evidence. Counsel referred to the cases of Okaibu versus Wonlo, Oguntayo and others versus Adebutu and others, Dagash versus Bulama, and Ajose versus Federal Republic of Nigeria. Citations are all provided. That the claimant's contention that he is entitled to an award of the sum of 5 million naira, which he allegedly expended on tradomedical treatment after his medical treatment was stopped at IOS Medical Center, is in the nature of special damages, which must be strictly proved by credible evidence. That the claimant failed to provide any evidence to support his claim that he expended 5 million naira on tradomedical treatment, because no receipts or any form of medical report was tendered by the claimant to support his assertions. The court was urged to refuse relief D. Counsel referred to Joseph versus Abubakar, Okeke versus Ondoaka, and Salami versus Savannah Bank Limited. Citations are provided. Now, with respect to relief E, for the sum of 20 million naira representing general damages against the defendant, it was submitted that there is no evidence that the defendant abandoned the claimant or failed to provide reasonable medical care after the accident. That the claimant confirmed in his statement of facts and his witness statement on oath that he was provided medical care by the defendant at the IOS Medical Center in Port Harcourt for a period close to 7 months after the accident occurred. And it is the defendant's case that the claimant was only discharged after the medical personnel had completed the treatment required by the claimant. All of the medical bills incurred during the 7 months period as a result of the claimant's injury were paid by the defendant, and he received his full salary on an ex-gratia basis until June 2013, even when the contract had expired at the end of January 2013. The court was urged to refuse relief E. Now, on relief F and G, it was submitted that the contract of service upon which the claimant was engaged was for a fixed term of 3 months, from 1st of November 2012 to 31st of January 2013, and expired by a fraction of time and not terminated. That reliefs F and G are therefore untenable and ill-conceived. Learned counsel referred to clause 10 of the contract of service and argued that even if it is assumed that there was some form of early termination which is not considered, the claimant will be entitled to 2 weeks pay in lieu. The court was urged to refuse reliefs F and G. Now, it was further posited that by Section 6 of the Employee Compensation Act 2010, unless an application is filed or a determination is made within 1 year after the date of death, injury, or disability arising from an occupational accident or disease, no compensation shall be payable, except the board of the NSITF is satisfied that there exist special circumstances which precluded the filing of an application within 1 year after the date of the occurrence. However, the board can only pay such compensation if the application is filed within 3 years after the date of the incident, that the claimant neglected to process the claim for compensation within the period of 3 years after he sustained the industrial injury, despite the efforts of the defendant to assist the claimant in assessing the payment from the Nigerian Social Insurance Trust Fund. Having failed to submit the said documentation in a timely manner and having been notified that the claim is statute barred, the claimant has failed to establish reasonable cause of action against the defendant. That even if the claimant has a cause of action, it should lie against the board of the NSIT and not the defendant. That the suit therefore constitutes an abuse of court process. Counsel referred to Wadialo in Civil Procedure in Nigeria, 2nd edition at page 433, Eshugbayi Eleko versus Frank Morris, and the case of Afonja versus Afonja. Citations are provided, as well as Thomas versus Olu Fosoye. Citations are all given. The court was finally urged to dismiss the suit in its entirety. Now, the claimant's submissions. The learned claimant's counsel submitted this long issue for the court's determination, to wit, whether the claimant has not proved his case and therefore entitled to the judgment of this court. It was posited on the sole issue that the defendant's case is that the claimant's case is that he was abandoned at the clinic and that while he was undergoing treatment for the injury he sustained while working for the defendant, his contract was terminated by the defendant. That since this piece of evidence was not contradicted by the defendant, the court should rely on said. Counsel referred to Mudasiru versus Abdullahi, as well as Magaji versus Nigerian Army. Citations are provided. Learned counsel referred the court to paragraph 2 of the deposition of DW and the answers elicited from her during her cross-examination on the 6th of October 2021 and the 14th of October 2021, and argued that since the witness has asked the court not to place reliance on her deposition, but to rely on Exhibit DW3, and also denied her evidence in chief, the defendant has no evidence before the court. Counsel referred to UBA PLC versus Jack Nigeria Limited. Citation is given that parties are bound by their pleadings, and any evidence that is at variance with averments in pleadings goes to no issue and should be discountenanced. Referring to Dr. Mansour Abdulkadir versus Abdulaziz Ahmed. Citation is also provided that the evidence of DW is inconsistent and the defendant did not reconcile the inconsistency in this evidence before the court, thereby damaging the case of the defendant. Counsel referred to Al Risala Prints and Publishing Company Limited against Akasim El Husseini. Citation is also given. It was further argued that if the evidence presented by the parties is weighed in an imaginary scale, the case of the claimant will weigh higher and the court should grant the relief in this suit. Counsel referred to Onwuka versus Edeala. Now, the defendant's reply on points of law. The defendant filed reply on points of law on the 28th day of January 2022, which was deemed as properly filed and served on the 2nd day of February 2022. With respect to the argument in paragraph 1.3 of the claimant's address, that the evidence of DW amount to hearsay and should be discountenanced, it was replied that hearsay means evidence which is being submitted by a person or witness who did not personally witness the incident which he or she is testifying about. That hearsay evidence is inadmissible. Counsel referred to section 37 of the Evidence Act, that one of the exceptions to the hearsay rule is evidence given by a company's official on behalf of such a company as stated in Section 41 of the Evidence Act, that in this case, Titilola Olusekun, who was called by the defendant, clearly stated in paragraph 12 of her deposition that she was testifying based on the official records of the defendant company. Therefore, the exception applies to her testimony. Counsel referred to the case of STB Limited versus Interdrill Nigeria Limited, as well as the case of Brilla Energy Limited versus Federal Republic of Nigeria. Citations are provided. The court was urged to discountenance the submissions of the claimant's counsel and to dismiss the suit. Now, court's decision. I have poured over the pleadings, evidence, and arguments of both learned counsel to the parties in this suit, and I am of the humble view that the only issue to be determined in this suit is whether, on the balance of probabilities and preponderance of evidence before the court, the claimant has proved his case to be entitled to the relief sought. In order to discharge the onus on him and prove his claims as required by law, the claimant gave evidence in chief via his depositions that were made on the 6th of December 2018 and the 19th of November 2020. During his cross-examination, the claimant answered that he has diploma in shipping and aviation management and also a diploma in theology, that he applied to the defendant via his email address udsoniforreal@yahoo.com and interviewed before being employed by the defendant for duration of 3 months, and the contract expired sometime in March 2013 by exclusion of time. That when he was on sick bed, the defendant extended the contract by 1 month. The witness confirmed that after the accident on the rig, the defendant took him to SOS International Hospital in Port Harcourt, where he was admitted and discharged the following day. He denied stating in his pleadings that he was treated for 7 months and insisted that he was treated for only 1 day and abandoned because the defendant wanted to save cost. That after he left SOS Hospital, he had to seek for medical treatment in other medical facilities such as Avon Specialist Hospital in 2017, 4 years after the incident, because his leg was getting bad. That the treatment at Avon Hospital, where he had minor surgery, was a continuation of the previous treatments, and he cannot recall the cost of the treatment. That in the course of pursuing his claims for compensation, he has engaged 3 lawyers, including the present one, and he is not aware that the defendant wrote to his first lawyer, Chief FCO Imehiale, a letter dated 19th of February 2013, informing him that the application for compensation should be directed to NSITF. That he is also not aware that as part of effort to assist him to be paid his compensation by NSITF, the defendant requested him to fill forms for the processing of his claims. That he is also not aware that the defendant sent him an email forwarding the forms to him 3 years after the incident, when he had not submitted the forms. That even though he read the statement of defense filed in this suit, he did not see copy of the email sent to him by the defendant. He denied that even though his contract had expired by exclusion of time, the defendant paid him salary when he was undergoing treatment. Now, the evidence in chief of the defendant's sole witness, Titilola Olusekun, an accountant and defendant's rig controller, is at the post in her statement on oath filed on the 22nd of March 2021. During her cross-examination, the witness answered that she was employed by the defendant between 1st of October 2010 and 31st of December 2020, and she is no longer a staff of the company. That the claimant's contract with the defendant elapsed on the 31st of March 2013, and no extension was granted to the claimant. She, however, stated that based on Exhibit DW3 and the record, there was an extension, and that she was not the HR when the incident happened. That even though she does not have person information, she is, however, representing the company based on the information in their records. That based on paragraph 3 of Exhibit DW3, she has not come to lie to the court, and that the court should rely on Exhibit DW3. That she is not aware if the defendant pay any salary to the claimant after the expiration of the 3 months contract of employment. That she has been to the court and to Port Harcourt several times, and she signed her deposition at the court registry. That during the employment of the claimant, the claimant submitted to the company all the documents listed in paragraph 5.11 of her deposition, and she does not know if the claimant was visited while in the hospital, but that she expects the HR personnel to have checked on the claimant, that she knows NSITF, and from her knowledge, the claimant was to fill the forms within 2 years, and from the emails and records, the claimant procured, the company procured NSITF forms and gave to the claimant and asked him to submit before the deadline. The witness further answered that to the best of her knowledge, the claimant was discharged from the hospital about 7 months after he was admitted, and refuted the insinuation that the NSITF funds were sent to the claimant while on admission in the clinic, that the defendant would not have discharged the claimant from the clinic, but the claimant was discharged by the doctors, that the claimant was communicated via email, and that Exhibit DW7, addressed to the defendant's managing director, requested the defendant to forward the listed documents to NNPC for the purpose of assessing the funds for the claimant. She affirmed that when the staff is injured and sent to a clinic, the medical bills are sent to the company, and the company will also have a copy of the resumption report indicating that the victim has resumed work, that the company also has the bank details of each of its staff, so that it is not the responsibility of the company to produce the 3-month schedule of payment, as anybody can do that. That while the documents listed in Exhibit DW7 in possession of the company can assist the claimant in assessing his funds in NSITF, the responsibility of filling the forms rests with the staff personally, that in the course of her work with the defendant, she did not come across exhibits DW1 to DW11, that exhibit DW4 was addressed to the defendant, and same was communicated to the claimant who has the responsibility to fill the forms, that the claimant was a roustabout in the defendant, and that she was the management accountant in 2010 and promoted to cost controller in 2014. And in 2016, the post of cost controller was changed to re-controller, which was her position. That from the records, the claimant was in the hospital for 7 months and he could not have been abandoned at the clinic and discharged. So there was no need for further medical attention. That her testimony is based on the records and her knowledge, because even though she was in the company, she was not involved in the claimant's matter. Now it is pertinent to make the point that from the claimant's pleadings and reliefs in this suit, the claimant is not claiming for compensation under the Employees Compensation Act. No wonder the Nigeria Social Insurance Trust Fund Management Board is not joined as a party to the suit. The claims before the court are for alleged wrongful termination of employment, general damages, special damages, payment of monthly salary from July 2013 to date of delivery of judgment, and salary in lieu of notice. Since the grounds of the claimant is that the defendant abandoned him after he sustained injury while performing his duties at the defendant's West Polaris rig at Zabazaba 3 Ajib location, Port Harcourt, River State, on the 4th of January 2013, the onus is on the claimant to establish that the defendant owes him duty of care and to take reasonable care to provide not just safe equipment, but also safe work system. This is with a view to proving negligence on the part of the defendant, thereby resulting in the injury to the claimant, for the defendant to be held liable in damages. In the case of Cabo Air Limited versus Ismail Mohammed, citation is provided. The Court of Appeal held as follows regarding negligence or duty of care in employment cases, and I quote, "It is also settled that the liability of an employer under the duty of care rests upon the law of tort rather than on the law of contract. And this is because under the general law of tort, a duty of care is said to arise when two persons are so closely and directly related that the activities of one of them may involve an acceptable and appreciable risk of injury to the other. See Donegal versus Stevenson. Such a close and direct relationship exists between an employer and his employee, and thus, under the ordinary principles of tort, the employer owes duty of care and he is liable for negligence. See Baker versus James, Mackinnon versus Iberia Shipping Limited, Heavy versus New Metal Board Mills Limited, Supra. An employee is, however, at liberty to sue under contract if there are special damages. Matthews versus Kuwait Better Corporation, end of quote. See also Iyere versus Bender Feed Flour Mill Limited and Mr. Benjamin Eyako versus Leventis Motors, unreported decision of this court in suit number NIC/0W/49/2014, decision of Honorable Justice O.Y. Anoue, delivered on the 3rd of December 2018. Having reviewed the evidence in this suit, it is obvious that the claimant was employed by the defendant via exhibits CW1A and DW1 on the 9th of October 2012 as a roustabout, and while performing his duties on board the defendant's West Polaris rig at Zabazaba 3, Ajib location, Port Harcourt, he sustained injury on his right foot and immediately taken to the SOS Medical Center at SMI Clinic Limited, Intel Camp, Port Harcourt, for medical attention. These facts are not in dispute and they do not need further proof in this suit. The main issue in contention between the parties is the allegation by the claimant that while he was still being treated for the injury, the defendant abandoned him to his fate and instructed the hospital to discharge him even when he had not been certified fit for discharge. The defendant on his part stated that the claimant was in the hospital for 7 months and was only discharged after the medical doctors were satisfied with his state of health, and that the defendant never influenced the discharge of the claimant from the hospital. I have seen from paragraph 6 of the statement of facts, paragraph 6 of the claimant's statement on oath, as well as exhibits CW1F and CW1G, where the claimant pleaded and stated that he was hospitalized for about 7 months before treatment was withdrawn, and he was discharged contrary to medical advice. While the accident occurred on the 4th of January 2013, and his discharge from the hospital via exhibit CW1B was on 27th of March 2013, the further treatment sought by the claimant via exhibit CW1J was on the 13th of June 2017, a period of about 4 years after the accident and his treatment at International SOS SMI Clinic Limited. Exhibit CW1B, tendered by the claimant, the work fitness certificate, does not seem to help his case of abandonment by the defendant. It is also noted that during the cross-examination of the claimant on the 3rd of February 2021, he vehemently denied, stating in his pleadings that he was treated for 7 months and informed the court that he was treated for only 1 day and abandoned by the defendant in order to save cost. This piece of evidence elicited from the claimant during cross-examination is clearly at variance with paragraph 6 of his statement of facts and paragraph 6 of his statement on oath, where he stated, and I quote, that I was so hospitalized for about 7 months. I was on crutches with excruciating pains at the clinic when suddenly the defendant, my employer, called for my discharge from clinic, contrary to medical advice and opinions of the medical doctors in the clinic, just to save costs for the defendant and to punish me. Hence, further treatments were withdrawn from me. I was subsequently abandoned and later pushed out of the clinic amidst the excruciating pains and left to my fate. That was towards the end of July 2013, end of quote. While exhibit CW1B also supports the position that the claimant was treated from 7th of January, I take that again, while exhibit CW1B also supports the position that the claimant was treated from 4th of January 2013 to 27th of March 2013 and was scheduled for further review on the 27th of April 2013, exhibit CW1K, though not dated, merely asked the claimant to be going to his assigned HMO with effect from 30th of January and discontinue going to ISOS for follow-up checks. There is clear case of inconsistency in the evidence of the claimant with respect to the duration of the treatment he received at the International SOS SMI Clinic Limited, which is very material to this suit, where he is alleging abandonment by the defendant. The law is banal that a party who is alleging abandonment, the law is banal that a party who adduces inconsistent evidence over one and the same issue damages his case unless the inconsistency is reconciled by the party. See Al-Salah Printing and Publishing Company Limited and others versus Kasim El Hosseini and others. Citation is provided, as well as Jediel Balanco and others versus Peace Estefano Balanco. Citation is also provided, where the appellate court held as follows, and I quote, "It is settled law that a witness who has given materially inconsistent evidence on oath ought not to be believed. Such evidence ought not to be relied upon by the court. Such a witness is not only unreliable, but not a truthful witness. There is no reason why such evidence should be believed and acted upon. A party is not allowed to present to the court inconsistent evidence contrary to his pleadings and or assertions. See Ajide versus Kelani, Ezemba versus Ebeneme, Ogunde versus Abdul Salam. The trial court was right not to have attached any probative value to Exhibit 4 as proof of his birth to the respondent's late father." End of quote. With respect to the reliefs in this suit, it is noted that Relief A is for an order that the termination of the claimant's employment without notice or salary in lieu is wrongful. I have looked at Exhibits CW1A and DW1, which are the same, and it is manifest at Clause 1 that the employment was for a fixed term of 3 months from 1st of November 2012 to 31st of January 2013. To better appreciate the terms of the contract, it is opposite to reproduce Clause 1 of Exhibit CW1A and DW1 to wit, and I quote, the term, "Your fixed term employment is for a period of 3 months, commencing on November 1st, 2012 and ending on January 31st, 2013. The term, this is without prejudice to the fact that your employment shall cease immediately the West Polaris rig is moved to another location outside Nigeria, notwithstanding that the term is yet to expire." End of quote. The contract was for a fixed term of 3 months as agreed by the parties, and it is not the business of the court to extend said. The parties are bound by the terms of the agreement voluntarily entered into. Since the contract expired on the 31st of January 2013, albeit when the claimant was still in the hospital receiving treatment for the injury, there is no basis for the allegation of wrongful termination of employment, even if there was an extension by 1 month, as could be gleaned from Exhibit DW3. The extension ended on the 28th of February 2013. The contract ended by a fraction of time, as agreed by the parties, as so fine and whole. This Relief A is therefore refused. Now, with respect to Relief B, for an order that the claimant is entitled to group life policy and group personal accident insurance scheme, may I state straight away that these policies are provided in Clause 7.2 of the Contract of Employment, Exhibit CW1A and DW1. It must, however, be made clear that the coverage of these policies were limited to the duration of the contract. While the claimant sustained the injury during the lifespan of the contract, he has, however, failed to show the court the scope of these policies and what he is entitled to, and it is not for the court to speculate in the circumstances of this case. Relief B, therefore, succeeds only to the extent that the claimant is so entitled to the defendant's group life policy and group personal accident insurance policy. Now, with respect to Relief C, for an order that the claimant sustained serious crush injury on his right leg on the 4th day of January 2013 while on duty at the defendant's West Polaris rig at Zaba 3, Ajib location in Port Harcourt, River State. I have heard earlier in this judgment that this fact is not in dispute because the defendant is not denying the fact of the claimant's injury. Relief C is therefore meritorious only to the extent that the claimant indeed sustained injury to his right leg on the 4th of January 2013 while on duty at the defendant's West Polaris rig at Zabazaba 3 Ajib location in Port Harcourt, Rivers State. It may be pertinent to state, even passively, that I agree with the argument of the learned counsel to the defendant that reliefs A, B, and C should have been in the nature of declaratory reliefs and not for orders of court as couched in this suit. This is because they contain no specific monetary claims and their success will be of little or no relevance when it comes to enforcement. Now, for relief D, for an order that the defendant shall pay the claimant the sum of 5 million naira being the out-of-pocket expenditure incurred during the period of his abandonment, medical bills, tradomedical expenses, and drugs and treatments at the chemist, it is obvious that the relief is in the nature of special damages. It is the law that it claims for special damages. The claimant must specifically plead not only the damages with the particulars, but must also prove same strictly with verifiable and cogent evidence. In other words, the claimant must not only plead and give the required particulars of the special damages sought, but he must also adduce credible evidence to support the claims in order to satisfy the court on how he arrived at the sum claimed as special damages. See Ndukwe versus Agu and Mantec Water Treatment, Nigeria Limited versus Petroleum Special Trust Fund. Citations are all provided. I have however gone through the statement of facts and the claimant statement on oath. And apart from paragraph 13, where the claimant pleaded and stated that he was hospitalized at Avon Specialist Hospital between 13th of June 2017 and 24th of July 2017, where he spent 680,000 naira, leaving balance of 220,000 naira, which he is here to pay. There is no place where he pleaded with particulars and proved the various heads of sums that make up the sum of 5 million naira claimed in this suit. To even worsen the case of the claimant, Exhibit CW1J, tendered by him as proof of the further treatment he received at Avon Specialist Hospital Limited from 13th of June 2017 to 24th of July 2017, does not include the medical bills he allegedly incurred at the hospital. In the circumstance of this relief for reimbursement of medical expenses, the claimant is expected to produce before the court the medical bills and receipt issued by the medical facilities where he claimed to have been treated or bought drugs from. This he failed to do. Relief D therefore fails and same is hereby refused. With respect to relief E, for the sum of 20 million naira, representing general damages against the defendant for the consequential abandonment of the claimant at the clinic while suffering neglect and psychological and physical trauma which the claimant was subjected to, I have held in this judgment that the claimant failed to establish negligence on the part of the defendant, which would have been the basis for the award of general damages in this suit. Having failed to prove that he was abandoned by the defendant and negligence on the part of the defendant, he is not entitled to this relief. The relief therefore fails and is also refused. For relief F, for the total sum of 308,300 naira, representing the claimant's monthly salary for the period between July 2013 until judgment is delivered, an interest of 30% of the sum, I do not see how the claimant can claim monthly salary from July 2013 until date of judgment, when the contract he voluntarily signed is for a fixed term of 3 months, from 1st of November 2012 to 31st of January 2013. Since the contract expired on 31st of January 2013, he is not entitled to salary from July 2013. It is important to state that even if there was an extension of the contract, as could be seen in the Exhibit DW3, the extension was for a period of 1 month and expired on the 28th of February 2013. The claim fails and is hereby refused. Now, relief G is for an order that the defendant shall pay the sum of 616,600 naira, representing the claimant's 2-month salary in lieu of the termination of his employment. I have gone through the contract agreement, Exhibit CW1A and DW1, and I have not seen where it is stated that a party to the agreement is entitled to 2 months notice or 2 months salary in lieu. The claimant's counsel has not drawn the court's attention to such provision in the agreement. Clause 11 of Exhibit CW1A and DW1 provide, and I quote, either party may terminate this contract by giving to the other party 2 weeks written notice, or by paying to the other party 2 weeks salary in lieu of notice, end of quote. Even if it is held that the claimant's employment was terminated by the defendant, which is not the case in this suit, as the contract ended by a fraction of time, what the claimant is entitled to is either 2 weeks notice in writing or 2 weeks salary in lieu of such notice. Even statutorily, since the contract was for a fixed term of 3 months, the claimant is entitled to only 1 day notice pursuant to Section 11, sub 2A of the Labor Act. Relief G is also refused. In the final result, the claimant's case succeeds in part only with respect to relief B and C. All the other reliefs are refused for want of proof. Judgment is entered accordingly, and I make no order as to cost.
The court pleases. My lord, we would like to most thankfully thank your lordship for the erudite judgment. We're very grateful, sir.
You're welcome. So you get copies immediately after the public holidays next week.
Well, my lord. Well, my lord. I wish your lordship a safe journey back to Port Harcourt.
Thank you.
We'll not get anything.
Yes, Registrar, can you call the second matter?
Let's see. I wish to say, join.
Peace. Should for the bakery.
Yes, who are the counsel in this matter? KCA Dutak against Fadiso Manpower.
Yes, my lord. GG People, I'm here, my lord.
GG People.
My humble appearance, my lord, is for, yes, my lord. My humble appearance is for the claimant respondent. My name is GG People, my lord.
Thank you. Yes. Is there any other counsel? Who is appearing for the defendant applicant?
My lord, is supposed to be Mr. E.A. Onyeso from the firm of NI below you.
Yes, sorry. Now, this is the course ruling. This ruling is in respect of the defendant applicant's motion on notice, dated 1st of November 2021 and filed on the 29th day of November 2021, praying this court for the following reliefs. 1, an order for the leave of this honorable court to file an appeal against the ruling of this honorable court delivered on the 28th day of September 2021 against the defendant applicant. 2, an order of this honorable court extending time within which to file notice of appeal against the ruling of this honorable court delivered by this honorable court on the 28th day of September 2021. 3, an order deeming the notice of appeal as properly filed and served, the appropriate filing fees having been paid. And 4, an order staying further proceedings in this suit, pending the hearing and determination of the appeal filed by the defendant applicant against the ruling of this honorable court delivered on the 28th day of September 2021. And 5, for such order or orders as this honorable court may deem fit to make in the circumstance. The 8 grounds for the application are as follows. 1, on the 28th day of September 2021, this honorable court delivers ruling against the defendant applicant, dismissing notice of no objection, challenging the jurisdiction of this honorable court. 2, time set out for filing of notice of appeal has lapsed, hence the application for extension of time. 3, the appeal is an interlocutory appeal. 4, the issue of jurisdiction is a special circumstance to justify an order of stay of further proceedings in this suit, in this court, until the appellate court resolves same at the Court of Appeal. 5, the defendant applicant has disclosed good and arguable grounds of appeal on the notice of appeal. 6, the defendant applicant has raised recondite issue of law in this notice of appeal. 7, the defendant applicant has a constitutional right of appeal against the ruling of this honorable court. And 8, the court has power to grant stay of proceedings. In support of the application is an affidavit of 13 paragraphs deposed to by Beauty Nagbi, the secretary, the law firm of N.A. Ibiloye and Co. Annexed to the application is the notice of appeal filed on the 29th of November 2021, which is marked as Exhibit A. In compliance with the rules of court, the applicant's counsel also filed written address wherein this loan issue was identified for determination. That is, whether the applicant has made out a case for the grant of the relief sought in the application. It was submitted that this court has the power to grant leave to appeal and extension of time to appeal, and also order for the stay of proceedings in this suit pending the determination of the appeal. That since Exhibit A, which is the notice of appeal, discloses good and arguable grounds of appeal, because the issue relates to the jurisdiction of this court, the application for stay of proceedings should be granted. That an issue of jurisdiction constitutes a special circumstance for stay of proceedings. Counsel referred to the cases of Eze versus Okolunji, Nigerian Westminster Dredging and Marine Limited versus UFT Engineering Limited, Nika Fishing Company versus Lavina Corporation, General Oil Limited versus Oduntan, Akilu versus Faweimi, Okeke versus Yaroson, Mobi Producing Nigeria Unlimited versus His Royal Highness Oba Unisa. Citations are all provided. The court was asked to grant the application and stay further proceedings in this suit, or in the alternative, adjourn the suit Saneda. In opposition to the application, the claimant respondent filed a reply address on the 14th of December 2021, wherein learned counsel proposed this loan issue for the court's determination, to wit, whether the honorable court has the jurisdiction to entertain the motion filed by the defendant applicant and to grant the relief sought thereunder. It was argued that prayer 1 of the application for leave to file an appeal against the decision of this court is misdirected, because by section 243 of the 1999 Constitution as amended, such leave can only be granted by the Court of Appeal. That where the time stipulated for appeal has elapsed, an application for extension of time to appeal can only be made to the appellate court and not the trial court. Counsel referred to NNPC against OE Nigeria Limited, Savannah Bank against CBN, and Odofin versus Agu, as well as Inca Nigeria PLC versus Bolex Enterprises Nigeria Limited. Citations are provided. The learned counsel listed the general principles for the grant or refusal of stay of proceedings to include: 1, there must be a pending appeal. 2, the applicant must show that if the appeal succeeds, the success will not be in vain. 3, that in the circumstances of the case, a refusal to stay proceedings will be unjust and inequitable. 4, that the rest of the matter will be destroyed and the judgment of the court rendered nugatory if the application is refused. And 5, that there exist special and exceptional circumstances justifying the grant of the application. For example, where the notice and grounds of appeal raised substantial issues. It was further posited that since there is no valid appeal, the relief for stay of proceedings cannot be granted by the court, that the mere phrasing of issue of jurisdiction is not conclusive to warrant the grant of stay of proceedings. Counsel referred to Nika Fishing Company versus Lavina Corporation, as well as IGP versus Fayoshe. Citations are provided. The court was asked to refuse the application with exemplary cost. Now, cost decision. Having poured over the motion on notice, the supporting affidavit, the exhibit, as well as the written submissions of both counsel, it is obvious that the reasons given by the defendant applicant are that having been dissatisfied with the ruling of this court delivered on the 28th of September 2021, they have filed notice of appeal, albeit out of time, and now needs leave of court to regularize the notice of appeal and to also stay proceedings in this suit pending the determination of the appeal. See paragraphs 4, 5, 7, 8, 9, 10, 11, and 12 of the supporting affidavit. Exhibit A, attached to the supporting affidavit, is the notice of appeal filed at the registry of this court on the 29th of November 2021. Having considered the reliefs on the face of the motion paper, may I draw attention to the provisions of section 243, sub 2 and 3 of the 1999 Constitution as amended, which requires leave of the Court of Appeal to appeal against the decision of this court in civil cases, except in cases of fundamental rights. The law as it stands now is that any party who is dissatisfied with the decision of this court in any civil case, except fundamental rights cases, and intends to appeal against such decision, requires the leave of the Court of Appeal. Such leave of the Court of Appeal is a precondition and sine qua non to the validity of any such appeal. See Governor of Rivers State of Nigeria and another versus Iwua Friday and others. Alhaji Amen A. Akoshile versus National Identity Management and another. Governor of Rivers State of Nigeria and another versus Agi Princeway and others, as well as John Holt PSC versus Martin Nwabua. Citations are all given. I therefore agree with the apt submissions of the learned counsel to the claimant respondent that this court has no jurisdiction to grant relief one of the application for leave to appeal against the decision of this court. In the absence of such jurisdiction to grant leave to appeal, the court cannot extend the time required for such appeal and can also not deem any notice of appeal as having been properly filed and served. Reliefs 1, 2, and 3 cannot be granted by this court, and they are hereby refused. The appropriate venue or forum for such reliefs is the Court of Appeal. I so find and hope. With respect to relief 4, for an order staying further proceedings in this suit, pending the hearing and determination of the appeal, I must state straight away that in the absence of any leave of the Court of Appeal, there is no valid appeal to warrant stay of further proceedings in this suit. I say this because by section 47 of the National Industrial Code Act 2006 and order 64, rule A sub 2 and 3 of the rules of this court 2017, the mere filing of an appeal or an application for stay cannot operate as stay of proceedings or stay of execution. Order 64, rule 14 sub 1 of the rules of this court 2017, which provides for the filing of an application of this nature, states, and I quote, where a matter is ongoing and the party is applying for stay of proceedings pending appeal, the party shall, in the application for stay of proceedings, A, file an application for stay of proceedings pending appeal, B, pay for the compilation of the records of proceedings for which the party is seeking stay of proceedings, C, exhibit certified true copies of the record of proceedings for which the party is seeking stay of proceedings pending appeal, and exhibit evidence that there is a valid appeal before the Court of Appeal. D, exhibit evidence that the appeal has been entered in line with the appropriate rules of the Court of Appeal. And E, exhibit evidence that the party has been granted leave by the Court of Appeal, where leave is required, either by law or by the rules or the practice directions of the Court of Appeal. End of quote. What is manifest in this application is that almost all the preconditions enumerated above have not been met by the defendant applicant. There is nothing before the court indicating that the applicant has paid for the compilation of the records of proceedings and that such records of proceedings have been compiled. There is no evidence that leave to appeal has been granted by the Court of Appeal and that the appeal has been entered. I therefore hold that the defendant applicant has not made out a case to be entitled to the reliefs in this application. In the circumstance and for the reasons given above, I hold that this application lacks merit and same is hereby dismissed. Ruling is entered accordingly, and I make no order as to cost.
As the court pleases, we are grateful to my lord for the well-reasoned ruling.
Thank you. Yes, Registrar, give me a date for 24th of May.
It's convenient, my lord.
Case is adjourned to 24th of May 2022 for trial.
As the court please.
Thank you. Call the last case for ruling. Yes, Sammy Savior versus Ogendene. Who are the counsel?
Yes, my lord. With utmost humility, my lord.
Yes.
I am M.O. Thomas.
M.O. Thomas.
M.O. Thomas for the claimants, judgment creditor, respondent.
Yes, who appears for the defendant judgment debtor?
My lord, we are here.
Yes.
Yes. With utmost humility, my lord. E.C. Obasi. E.C. Obasi. My lord, our humble appearance is for the
initials again.
E.C. E for Emmanuel. C for claimant.
Yes,
Obasi.
E.C. who?
E.C. Obasi.
Obasi.
A.S.I.
Yes.
Yes. My lord, our humble appearance is in this. May I please?
Thank you. This is the court's ruling. This ruling is in respect of the judgment debtor applicant's motion or notice dated 16th of November 2021 and filed on the 22nd day of November 2021. The application, which is brought pursuant to Order 17, Rule 1 of the rules of this court 2017, prays for the underlisted reliefs. 1. An order of this honorable court allowing the applicant to pay the judgment sum of 922,118 naira 73 kobo by monthly installment of 80,000 naira until the entire judgment sum is liquidated. And 2, for such further and other orders as this honorable court may deem fit to make in the circumstances of this case. The grounds for the application is that the judgment debtor applicant is in a financial crisis and that the movable and immovable assets of the judgment debtor applicant have been taken over by the Assets Management Corporation of Nigeria, AMCO. The support of the application is an affidavit of 12 paragraphs deposed to by one Tamara Preye Didi, the litigation secretary in the law firm of C. Chris Ekemeze and Associates. Annexed to the supporting affidavit are 3 exhibits marked as exhibits A, OAS1, OAS2, and OAS3, respectively. Now, in compliance with the rules of court, the learned counsel to the applicant file written address wherein this loan issue is submitted for determination. that is, whether in the peculiar circumstances of this case, the court can exercise its power in favor of the applicant by granting this application. In arguing the application, learned counsel submitted that where a court delivers judgment in a suit, the court becomes functus officio, except for ancillary orders, such as an order for payment of the judgment sum by installment, that the grant of an application of this nature for an equitable relief is at the discretion of the court, which must be exercised judiciously, taking into consideration the competing interests of the parties. Counsel referred to Belliet Nigeria Limited versus Kachala, Unipetro Nigeria PLC versus Adireji, Rasaki versus Ajilola, Kasumu versus Shitabe, United Spinners versus Shattered Bank Limited, Akilu versus Fawemi, and Ironini versus Eheoko. Citations are all provided. Learned counsel referred to paragraph 4, 7, 8, and 9 of the supporting affidavit, as well as exhibits OAS1, OAS2, and OAS3, and argued that since the business of the judgment debtor applicant has been crippled by the acquisition or takeover of the judgment debtor applicant by the Assets Management Corporation of Nigeria, AMCON, the court should grant the application to allow the judgment debtor applicant pay the judgment sum by installments, that is, the sum of 80,000 naira per month until the entire judgment sum is liquidated. Counsel referred to ACB Limited versus Namani, as well as Chief of Air Staff versus Ian and Port versus Just Electricity Distribution PLC. Citations are provided. In opposition to the application, the claimant judgment creditor respondent filed counter affidavit of 12 paragraphs deposed to by the claimant judgment creditor respondent on the 21st of January 2022. Annexed to the counter affidavit are 5 documents marked as exhibits A, B1, B2, C1, and C2 respectively. In compliance with the rules of court, the respondent's counsel also filed written address where this loan issue is identified for the court's determination. That is, whether having regard to the facts of this case, this court can exercise its discretion in favor of the defendant judgment debtor applicant. In arguing the loan issue, learned counsel submitted that the application lacks merit because exhibit OAS1 relied upon by the applicant is an ex parte order which has since expired after 21 days of its grant, that there is nothing to support the claim that the judgment debtor applicant has been taken over by AMCON. The court was asked to refuse the application for payment of the judgment sum in installment and dismiss same, or in the alternative, order that the judgment sum be paid in 3 installments. It is apposite to note that the judgment debtor applicant filed reply on points of law on the 31st of January 2022. According to learned counsel, paragraphs 3, 4, 5, 6, 7, 9, 14, 17, 19, 20, and 21 of the counter affidavit contain extraneous matters by way of objection, prayer, legal argument, or conclusion, contrary to section 115, sub 1 to 4 of the Evidence Act 2011. The court was urged to discountenance those paragraphs and strike them out. Counsel referred to Ogriga and others versus Fidelity Bank PLC and others, as well as Ode versus Alaga and others. Citations are provided. It was further posited that since exhibits B1 and B2 are not signed, they are worthless and should be discountenanced by the court. Counsel referred to Omega Bank Nigeria PLC versus OBC Limited. Citation is provided. On the respondent's contention that the ex parte order has since expired, it was replied that by the provision of section 15 of the Asset Management Corporation of Nigeria, Amendment number 2 Act 2019, the order made ex parte shall subsist the judgment or final determination of the suit. It was further posited that since exhibits A, B1, and B2 attached to the counter affidavit were made during negotiations, they are inadmissible, notwithstanding the fact that they are not marked without prejudice. Counsel referred to section 196 of the Evidence Act, as well as the case of Ondo PLC versus Okwesei and another, citation is given. With respect to Exhibit C1 and C2, it was argued that since they are computer-generated documents, they fail to satisfy the conditions stated in Section 84, Sub 1, 2, and 4 of the Evidence Act 2011, and should therefore be discountenanced. Counsel referred to Dixon versus Silva and others. Citation is given. The court was out to grant the application. It is, however, noted that the judgment debtor applicants reply on points of law rather than responding to the arguments in the judgment creditor applicants, in the judgment creditor respondents' address, straight and went off the mark by responding to the paragraphs of the counter affidavit with respect to issues of facts. No wonder the judgment debtor applicant filed a 9-page reply address in response to a 3-page written address filed by the judgment creditor respondent. If the applicant wanted to bring further facts to the attention of the court, they should have filed a further and better affidavit together with a reply on points of law. In any case, the bulk of the submissions is more of re-arguing the positions canvassed in the applicant's written address in support of the application. The law is banal that a reply brief, reply on points of law, circumstance of this case is not meant to afford a party the opportunity to re-argue his case with a view to improving it, but to respond to fresh issues or points of law raised in the respondent's brief. A party cannot therefore use the occasion of filing a reply on points of law to sugarcoat his arguments in the main address. It is not meant to give a party a second chance to argue and improve on his argument in the original brief or address. See the case of Major General S.C. Sanya, retired, versus Federal Ministry of Environment, Housing and Urban Development, and others. Citation is given. Now, court's decision. Before I go into the substance of the application, I shall first resolve points of law raised by the learned counsel to the judgment debtor applicant with respect to some paragraphs of the judgment creditor respondent's counter affidavit filed on the 21st of January 2022. The first point relates to the argument that paragraphs 3, 4, 5, 6, 7, 9, 14, 17, 19, 20, and 21 of the counter affidavit contain extraneous materials by way of legal arguments, prayers, and conclusion. That since the said paragraphs contravene section 100, sub 1 to 4 of the Evidence Act, they should be discountenanced by the court. Having gone through the paragraphs of the counter affidavit in question, I must state that I do not see how they run foul of section 115, sub 1 to 4, particularly sub 2 of the Evidence Act. These paragraphs of the counter affidavit merely responded to paragraphs 4, 5, 6, 7, 8, and 9 of the affidavit in support of the application. I do not see any merit in this point of law, and same is hereby discountenanced. Now, with respect to the second point of law, that exhibits B1 and B2 should be discountenanced because they are not signed, may I state that from the deposition at paragraph 15 of the counter affidavit, the judgment creditor respondent did not produce exhibits B1 and B2 to prove any concluded agreement between the parties, but rather to show that there were steps to resolve the matter amicably, and sequel to that, a proposed term of settlement was submitted, which was allegedly altered, thereby making it impossible for the parties to resolve the matter amicably. The point of law with respect to the admissibility of exhibits B1 and B2 is obviously misplaced, and same is hereby discountenanced. The same position applies to exhibits C1 and C2, which shall be countenanced in this ruling. The argument that these exhibits should be discountenanced because they are computer generated is also misplaced. It is, however, apposite to state that even though the court has discountenanced the points of law raised by the judgment debtor applicant, I have, however, discovered a fundamental flaw in the judgment creditor respondent's counter affidavit. While I have seen from the court's record and also taken judicial notice of the fact that the judgment creditor respondent who testified before this court on the 30th day of November 2021 is a man, I have, however, seen that even though the judgment creditor respondent claim to have deposed to the counter affidavit filed on the 21st of January 2022. The passport photograph attached to the counter affidavit is not that of the claimant, but that of a lady. I have looked at the back of the passport photograph and there is no name indicated to enable the court ascertain who the lady is. This is a fundamental defect and no effort was made to rectify the contradiction. I do not think that the counter affidavit is competent in law. The counter affidavit filed on the 21st of January 2022 is accordingly discountenanced and hereby struck out. While it would seem that there is no counter affidavit to contradict the facts in the affidavit in support of the application, and those facts will ordinarily be deemed to have been admitted by the judgment creditor respondent, I must however state that in the circumstance of this application for payment of the judgment sum by installment, the grant or refusal of the application is at the discretion of the court, which must be exercised judicially and judiciously. In exercising the discretion in this application, I shall be guided by the facts in the supporting affidavit and the law, including the provisions of the rules of this court. The judgment debtor applicant deposed in paragraphs 3, 4, 5, 6, 7, 8, 9, 10, and 11 of the supporting affidavit that since the judgment debtor applicant's assets, movable and immovable, have been taken over by the Assets Management Corporation of Nigeria, AMCO, via order made by the Federal High Court on the 31st of January 2017 in suit number FSC/L/CS/1139/2016, the judgment debtor applicant is unable to pay the whole judgment sum at once, that the court should grant the application to enable the judgment debtor applicant liquidate the judgment sum in installments. Having perused the depositions in the affidavit in support of the application and exhibits OAS1, OAS2, and OAS3 annexed to the supporting affidavit, it is manifest that all the property, movable and immovable, belonging to the judgment debtor applicant have been taken over by the Asset Management Corporation of Nigeria pursuant to order of the Federal High Court that was made on the 31st of January 2017. I have equally seen in the exhibit OAS2 that between the period of 2nd of November 2011 and 10th of November 2011, the highest credit balance in the account of the judgment debtor applicant is a sum of 1,592,704 naira 68 kobo. It is the law that while a court has the discretionary power to order that judgment sum be paid in installments, the court must, however, be cautious so that the judgment creditor is not denied the fruits of the judgment awarded in his favor. In the case of Alhaji Tanko Isiaku versus Mr. Prince Chidi Ugu, citation is given. The Court of Appeal held as follows on what an applicant must establish in an application of this nature. And I quote, the grant of an application of this nature is purely discretionary, and the discretion must be exercised judicially and judiciously. In SCB Limited versus Dominico Builders Company Limited, the Apex Court held thus, an exercise of discretion can only be regarded as judicial if it proceeds from sound judgment revealed in proper reasons. Therefore, a discretion which is exercised on the misapprehension of the facts disclosed cannot be said to be judicial and judicious, and we entitle the appellate court to intervene. See also Akaje versus Adelakun and Aaron Idigbe versus Ihiako. The relief sought in the instant application is equitable, and like any other equitable relief, it requires a disclosure of sufficient facts. The applicant therefore owes a duty to place enough materials before the court to warrant the exercise of the discretion in his favor. See Williams versus Hope Rising Voluntary Fund Society, Chukwu versus Onya. It must be stated at this stage that the application for instrumental payment was actually granted by the lower court, save that it was on different terms from those championed by the applicant. An application for instrumental payment is like an application for stay of execution, and the applicant is required to show the existence of special circumstances before it can be granted. It is not granted as a matter of course. The burden is on the judgment debtor to satisfy the court that placing his liabilities and obligations against his income and all his assets, he deserves to be granted some equitable terms of settling the indebtedness. This position of the law has been stated in SCB Limited versus Dominico Builders Company Limited. By wherefore, JCA as follows: a judgment creditor has no burden to show that the judgment debtor has the means to pay the judgment debt immediately when there is an application for instrumental payment. He is entitled to expect that he will not be lightly denied the truth of his litigation. The burden is on the judgment debtor to satisfy the court that placing his liabilities and obligations against his income and all his assets, he deserves to be granted some equitable terms of settling the indebtedness. That is why his affidavit must present detailed facts with every candor. There cannot be a full and frank disclosure of nebulous facts from which no concrete and verifiable information can be ascertained. End of quote. See also the case of Mbas Motel Limited versus Wema Bank PLC. Citation is given as well as order 49 rules 11, 13, 14, 15, 16, and 17 of the rules of this court 2017. Having considered the circumstances of this case and the competing interests of both parties in this suit, it may be apposite to state that while I hope that the judgment debtor applicant has placed sufficient materials before the court, indicating that with the acquisition of his assets, movable and immovable by AMCON, pursuant to the order of the Federal High Court, his income is insufficient to take care of his liabilities and obligations, and should therefore be granted some equitable terms of settling the judgment debt of 922,118 naira 73 kobo entered in favor of the judgment creditors by this court on the 5th of November 2021. I am, however, of the considered view that the proposal to pay the judgment debt by monthly installment of 80,000 naira until the judgment sum is liquidated is ridiculous and unreasonable. This will translate to paying the judgment sum in more than 11 installments. In the circumstance and for the reasons given above, the application is granted, allowing the judgment debtor applicant to pay the judgment sum of 922,118 naira 73 kobo in 4 monthly installments. The first payment of the sum of 247,118 naira 73 kobo shall be made in the month of May 2022, while the balance of 675,000 naira shall be paid in the months of June 2022, July 2022, and August 2022 at the rate of 225,000 naira per month. Ruling is entered accordingly, and I make no order as to cost.
As the court pleases. The Lord, we are most grateful for the well-considered judgment.
As God please.
Hello, we are very grateful.
You're welcome. Yes, Registrar, can we have date? Give me a date for continuation of trial.
My Lord, I don't know whether my learned friend wants to continue to pursue he will not continue. Be honest and be precise about it.
I cannot compel them to.
Anyway, my Lord,
to discontinue. If they want to go ahead with the other aspects of the claim.
100,000, and I'm sure he wants to discontinue. He knows this.
Well, maybe let's take date. Yeah. The next adjourned date, we will look at it. I think the balance is just 100 and something thousand naira.
Yes, my Lord. My Lord, we are grateful for the ruling. And I don't think there's need for us to pursue the remaining balance. On that ground, my Lord, we'll be praying this court to strike out the remaining balance. We want to discontinue further proceeding, pursuant to the ruling of my lord.
Yes, Mr. Obasi, what is your response?
My response can almost be, is already known. My lord, I welcomed his application, and
Okay.
I must thank him also. Let me thank him that he was able to do this kind of gesture, to extend this kind of gesture towards us.
Yes, all right.
No.
Yes, since judgment has been entered in respect of the admitted sums, and the claimant's counsel has informed the court that he intends to discontinue with the other aspects of the claims, those aspects of the claim are hereby struck out.
As the God pleases. We are grateful, my lord.
Thank you. So you have a copy of the ruling immediately after the public holidays next week.
Thank you, my lord.
Thank you, my lord.
So thank you.
Thank you, my
That
lord.
is the end.
Also wish you safe trip back to Port Harcourt, my lord.
Thank you.
Mr. Obasi.
Yes.
Can you hear me?
As I can hear you, yes.
Okay, yes. It's all right. Thank you very much. I hope you're okay with the ruling.
I'm okay. I'm okay.
It's all right. Thank you. All right.
Thank you.
Thank you so much. All right. Bye.
Just please afford me the ruling so I can forward it to management of our company.
All right.
All right.
Oh, yes, madam. I know they will see what you get now, so. I know they see what you get. When you finish, you show me again. Can I go? But you can say, okay, it's screenshot. Wait, stop being phone in the use. Can you imagine? I still there. I beg, I come out to. The thing no they show you again, one.